This is Drayson Boyd of AmComp. I am the Member Services and Certification Manager. We will be presenting a WCP continuing education webinar 3 times a year, and they are free to all AmComp members. Most of these webinars will focus on federal and state legislative updates. Before we get started today, I want to review a few housekeeping items. Please take notice that we do operate under the antitrust policy. It is available for reference here on the slides. The antitrust policy will guide this conversation, and we ask that you adhere to it when submitting questions to our presenter. I'd like to introduce you to today's presenter, Andrew Pauly. Andrew serves as Public Policy Counsel for NAMIC in a cross-functional role supporting the state, federal, and international regulatory divisions of the Government Affairs Department. Andrew additionally works with the Workers' Compensation Council, Amicus Working Group, NAIC Working Group, and Policy Research Council. He covers civil justice reform issues and other international and regulatory concerns, among other issues. He joined NAMIC in 2018. Andrew also obtained his WCP designation in 2021. Prior to NAMIC, Pauly directly participated in several insurance initiatives, including the privatization of the state workers' compensation monopolistic system and residual claim runoff, medical malpractice insurance reform, and third-party unfair trade practice reform. Pauly has extensive experience in insurance defense, including defending large commercial claims and coverage issues. I'd like to thank Andrew for joining us today, and then from here, I'll turn it over to Andrew.
Thanks, Drayson. Can you hear me?
Yep, I can hear you well.
Okay, great. Thank you so much. So if we can move to the slides. Thank you for having me today, and welcome. Again, I am to this AmComp series dealing with updates and discussions of workers' compensation issues that may be affecting the market in some regard. Again, my name is Andrew Pauly, and I'm Public Policy Counsel for the National Association of Mutual Insurance Companies. As you can see, NAMIC is a large trade association for insurance companies with over 7 of the top 10 property and casualty insurers in the United States as members. We have as members large, medium, and small mutual companies, stock companies, insurance exchanges, and other various forms of business models. As we discussed, the initial presentation in this series started last year, and in that presentation, I tried to touch upon some issues in the international, the federal, and state landscapes. Over time, as this series progresses, we'll discuss areas that develop in these various forums. But for today's purposes, we're mainly going to focus on the federal. There's been so much federal activity in these matters that I think that may affect workers' compensation directly or indirectly. With the Biden administration taking over the presidency and the executive branch through the election, there's been many aggressive federal activities in this space, in workers' compensation space, either directly or indirectly, that is worthy of discussion. As most of you know, as we continue to watch Washington, Congress continues to debate funding the government and looking at President Biden's Build Back Better Act. This comes at an unprecedented time in recent years where, due to the various factors, as we all know, including COVID-19 and its devastation, there are added pressures on the U.S. workforce employers, and policymakers. Last week, it was announced that inflation was at 7% last month and was the 7th consecutive month at top 5%. The Federal Reserve is now preparing to raise interest rates to curb inflation. The Federal Reserve has also somewhat backed away from using the term transitory, which was the initial thought concerning the rise of inflation, that it would only be temporary. And some are believing that we may be in for the longer haul in regards to inflation. It has been noted that it's been the fastest 12-month pace of growth for inflation in nearly 40 years. This is fueled in some part by supply chain demands, as we all know, where there's pent-up demand, but not the goods, consumer goods or products for purchase at market. Additionally, there's been resurgent strains of COVID-19. We all know about Omicron, and we hear discussions, there may be others every day. And there continues to be discussions about full economic recovery or lingering issues for the U.S. due to the same. Now, while the insurance industry is adept at handling these issues and always have been, handling risk and financial solvency and various capital requirements, longer-term inflation, as we all understand, can impact to some degree rate adequacy and reserve adequacy, based on the fact that claims, especially medical, can be more costly to pay, and economic damages as a whole can be increased substantially. Costs of vehicles, technology, home repairs and replacement, medical innovations and surgeries, for instance. So continue to see what Congress will do. There has been a number of stopgap measures or funding resolutions to keep the government open. But again, that will affect many of the programs that affect, obviously, employers, workers, and stakeholders in workers' compensation systems. An issue I wanted to start out with today, one of the larger issues that I think has been resurgent, and one of these that pops up once in a while, several years, decades, is federal oversight of workers' compensation. Paramount in this discussion is the extent you may or may not be aware of the current actions of the U.S. Department of Labor, OSHA, and Congress to increase, as well as the executive, to increase the level of oversight by the federal government of state-based workers' compensation systems. Sometimes these are overt acts, and then sometimes they're issues that may not meet the public perspective or the light of day, so to speak. And we believe this one, if you're not watching it, you might not have caught it. But in the budget talks that continue about funding federal programs, included in the same was a request by the U.S. Department of Labor for, I think it was $124 million, I don't have that exact number, for funding to monitor on an ongoing basis state workers' compensation systems. In a justification that was filed for the proposal to Congress, a discussion was included of the 1972 National Commission on State Workmen's, is their terminology at the time, 1972 report, State Workmen's Compensation Laws. Now, those of you who have seen your WCP will know from the AMCOMP program that this study is discussed and this commission is discussed in detail in the study materials. So that discussion that remains very relevant today as we see a push for more federal agency activity. So if we go back and briefly look at the National Commission on State Workmen's Compensation Laws, as it was entitled, in 1972. This was a group that was impaneled, I believe, by the Nixon administration to take a look at overall how the various programs in the states were being implemented, and to try to provide some sort of, I guess, structure of thought leadership in this area. When you look at the findings, there was basically 5 objectives for a modern workmen's compensation program. First one being broad coverage of employees and work-related injuries and diseases. We hear for some of the first times the inclusion of occupational diseases in the structure and coverage. Substantial protection against interruption of income. Obviously, the 2 components of workers' compensation, indemnification and medical, are very important to the concepts and the grand bargain, if you will, that the trade-off from allowing lawsuits and preventing defenses by industry in regards to litigation. Another area was provision of sufficient medical care and rehabilitation services. Obviously, people can have differing opinions concerning this objective. Many would argue that this, of course, is being implemented, but obviously, as with any concept, some may feel that there's not enough provisions in this particular situation, and then there are others who feel that in many instances it goes too far. Cost utilization is extremely important, I think, as we know, and the ability to make sure that only necessary and reasonable injuries are being paid for, and sufficient care, though, needs to be given, obviously, to the worker, so that hopefully, if possible, they can return to work in a timely manner. Additionally, the report discussed encouragement of safety, and I think that, again, this is something that has strongly been implemented. Obviously, we have OSHA, we have state labor departments. The industry, the insurance industry itself, is very highly regarded as for safety and risk management, which obviously has effects on premium, loss costs, what you pay for workers' compensation. But again, at the same time, I think everyone shares in the fact that we want a safe workplace for workers to be able to perform their skills and tasks in a safe manner. And then I think this is kind of what the current federal situation is looking at, an effective system for delivery of the benefits and services. Also contained in that report were a list of subjects of essential and areas that should be delved into quite a bit. And I think some of those included duration of disability benefits, medical benefits, the extent of coverage, compensability decisions, rehabilitation, all the issues we deal with today, coverage under second injury funds where those are still around in certain states, expenses, resolution of conflicts, ability to litigate within a comp system, objections to compensability decisions, and so forth, degree of impairment, and then relation with other government benefits. We obviously have the federal government that enters into these issues as we deal with Medicare payments and Medicare secondary payer obligations, Social Security disability obligations, and other issues that I think is also a concern by the federal agency Whether it's warranted or not, I think studies will have to bear that out. But and then, of course, as we just discussed, methods of implementation. I'm sorry. Let me back up here a little bit. So, in a briefing memo prepared by staff, 2 members of Congress recently about that justification for that enhanced budgetary request for oversight, the DOL laid out some concerns that they have. They believe there's an ongoing and systematic decline in the adequacy of benefits provided to injured workers. And again, we're not sure what all they're basing this on, and they list under the state-based workers' compensation system. They list costs for disabling workplace injuries are being shifted to federal programs such as Social Security, disability insurance, because of reduced coverage under state laws. Of course, as we know, there are offset states, and there's different ways offsets are handled in these particular areas. But as I mentioned earlier, for instance, Medicare secondary payer has a very robust subrogation ability, and especially against workers' compensation systems and recouping payments that were not their primary responsibility. So I think there's avenues for discussion on this concern as well. But again, as mentioned, they seek empowerment of the OWCP to monitor and move to benchmarks for conduct within the state. So again, looking at potentially creating a preemption type of situation where the federal government can move in where states do not meet certain benchmarks for conduct. I think the other reference I would want to give to everyone is, and there's many sources out here, so this is not by any means exhaustive, is the 2016 DOL report that was put out right at the end of President Obama's administration. And it basically says, does the workers' compensation system fulfill its obligations to injured workers? And looking at that report, it kind of is noteworthy, and we're kind of mirroring, what we're hearing today from some of the findings in that report. Whether to increase federal role and oversight, including appointment of new national commission, federal tracking standards, state dashboards, best practices, and how to strengthen the linkage of workers' compensation with possibly enhanced data sharing among stakeholders, other comprehensive safety and health management programs. Whether to develop programs that adhere to evidence-based standards, and then, of course, coordination of SSDI and Medicare were all discussed in that report. It's a rather extensive report, and I encourage you to look at that if you have concerns in this area. So compare that to some of the concerns that was taken last year by NCOIL, the National Council of Insurance Legislators. They passed a resolution by the body in response to some of this federal budgetary activity. Again, these were not laws, so let's be clear as we continue in the discussion. These were not laws providing authority for this. This was merely a request in a Budget Reconciliation Act to move into these areas more abruptly. So in looking at the resolution that was passed by NCOIL, and I have a reference to the link there, they go into support for state-based workers' compensation laws and oppose federal oversight in any way, shape, or manner. They point out the state-based workers' compensation is an effective means of protecting injured workers. Which another point which I think is important is linked to each state's economy. Each state, we have 50 states and DC and various territories and so forth. Each one of those have a different economy in and of themselves. There's not the same workers across the board in each of those states, and some deal with unique industries and unique challenges that a one-size-fits-all system would possibly allow persons to fall through the cracks or not be taken care of as much as they are currently under state systems. And so the concern is this kind of one-size-fits-all standard, federal standard that drops down to the states. There's a discussion of the ability of states to experiment in areas that work and then discard those if they do not and move to better systems. So clearly the federal government is not that nimble. There is already robust monitoring in place and the ability to tailor remedies to specific concerns. I think I would add that there are arguments that state legislatures, as I mentioned, move much more expeditiously on issues of concern than Congress, who really there's not a whole lot getting through Congress right now. And if there was a issue of concern for workers or whatever the issue is, might not be moved as quickly. As we know, in most instances, there's already departments of labor and insurance commissioners, for that matter, that regulate workers' compensation systems in the states. And so there, could be unwarranted and costly redundancies in kind of having this dual system with overlap. And additionally, a number of insurance trades and the industry itself are concerned about federal oversight, including unnecessary and additional layers of oversight, repetitive disclosures, unwarranted mandates that cause waste in the system, and frankly, delays for workers' treatment and reentry to the workforce where possible. So I think you have both sides of this issue, wherever you come down on it, fairly concerned about this activity and where it needs to go. So I think going forward from here, what are the next steps? Again, Congress cannot get its act together, so it doesn't appear anything's going to be funded anytime soon. There continues to be continuing resolutions to keep the government open. There were recent hearings late last year for House Education, Labor, Workforce Protection Subcommittee. Many of you can probably find that testimony if it's of interest to you. But USDOL stated in those hearings that they believe they already had the legal authority to carry out these proposals. There was some countervailing legal research done, and there are folks out there that don't believe the OSHA Act confers any authority on the Department of Labor to monitor, regulate, or conduct oversight of state workers' compensation programs. And whether there's any other federal authorities, such as an ERISA plans, ERISA laws, or other laws, does not appear to be so. There is some limited authority, obviously, for Social Security to protect their interests, but nothing as broad and as expansive as this topic is or can be. So this is definitely an area of concern. Okay, so moving on. The next area I wanted to discuss with the group is federal vaccination mandate status. And I know we've heard a lot about this in the press and the news, and regardless of viewpoints on this topic, the decisions, how the courts handle it, how the government handles it, how employers handle it, employees handle it, these matters will affect many folks. I think, obviously, workers' compensation claims initially, should they become in effect, and later down the road, if there are, vaccination issues. And that's not to say that for the good of the country and the good of the will, it shouldn't occur. It's just factual components that will have to be dealt with down the road. Workforce participation in general, we have many in the workforce that have stated they would actually quit their job as opposed to being vaccinated. Now, some are extremely serious about this, and some are only maybe making the statement to try to thwart the need to do it. But I think most people agree there is a percentage of the workforce that would be affected by a mandatory requirement. Supply chain resolution, again, need the workers there, need people in place, need healthy workers to be able to get the economy completely moving again. There's issues of viability and liability for employers. There are state law proposals out there that I won't go into in depth today, but that prevent forced vaccinations and any retribution concerning failure to take adverse action against an employee that doesn't want to get a vaccination. And then all of this kind of plays into an analysis of the PrEP Act, the Public Readiness and Emergency Preparedness Act, because of potential liability protections that the PrEP Act gives to employers could be eroded, depending on how all of these scenarios would potentially play out. So in September of last year, the Biden administration issued executive orders that all federal employers, federal contractors, and all businesses with 100 or more employees must be vaccinated by a certain period or face fines from OSHA. So what was interesting from this was the breadth and the reach, and the fact that OSHA may be fining private employers for failing to comply with these issues. So it really was going to be a tough situation where employers were going to have to decide if they were going to terminate folks for failure to comply because of this OSHA liability. And then again, other state law ramifications, as mentioned, or pending proposals that could cause them issues for terminating the person. The additional issue was it was 100 or more employees was the determination. 99 and under were exempt. And what I'm mainly talking about in this discussion is the private employer mandate, this 100 or more employees. Federal employees and federal contractors, those are employees of the federal government. Employers can set reasonable parameters for their employees, although these may play out in litigation as well. But mainly right now, I'm just talking about the 100 or more employees mandate. On November 12th of last year, a Fifth Circuit Court of Appeals stayed the matter. In question was OSHA's use of a ETS, emergency temporary standard, that allowed bypassing typical notice and comment proceedings for 6 months if the employees are exposed to grave danger, important buzzwords, and that such emergency standard would be necessary. The court Fifth Circuit in its decision was not buying any of this. They did not believe this was, a delicate surgical protection issued by OSHA, but yet it was a one-size-fit-all sledgehammer. This is their words, and completely dismissed the grave danger requirement. So we had a number of cases in the Sixth Circuit as well, and they decided differently. They did not believe that a stay was warranted. They wanted to let the vaccination mandate go into effect. I would also note in the Fifth Circuit decision, the court mentioned that in the 50 years of this ability, this ETS standard by OSHA, calling for an ETS, that they'd only issued 10 in 50 years. 6 of the 10 were challenged in court, and only 1 survived judicial scrutiny. So in the history kind of this ETS concept, there's only been 1 of these that survived a judicial appeal. The court went on to discuss the over-inclusiveness applying to all workers in all industries, regardless of risk. So, again, the person at a desk job that maybe didn't even see the public, as opposed to someone that's possibly on the front line, seemed over-inclusive, over-broad, and at the same time, under-inclusive. Because if, in fact, to prove this, to get this ETS, to get the mandate to be allowed for vaccinations, they had to show that everyone was in grave danger. But then the question became, what about the 99 and under crowd? So everyone 100 and over were in grave danger, and then there was no concern about the 99 and under crowd. So also, of course, the discussion was of a time element. If this is an emergency, we're in the 2nd year of the pandemic. And so that tended, I think, to possibly weaken the case as well. So the Supreme Court granted certiorari, which of course means that they decided to take the case up expeditiously and hear it. They heard oral arguments and briefing from parties. Some of the issues, as we discussed, were federal authority to issue. What does grave danger mean? Police powers and public protection. I mean, I think we all want the government to be able to some extent, protect the public and do that which is necessary to keep them away from harm. Again, the issue is how far does that go? How far does that extend? And then again, talking about that 100 employees, where do you come up with that number? So, hot off the presses, we had a decision last week, late last week on Thursday. So this is fairly up to date. This is up to date. The case of National Federation of Independent Businesses versus the Department of Labor, and then there were several states versus the Department of Labor. The court looked at this matter and said over 84 million employees will be subject to the mandate. They disagreed with the Sixth Circuit that a stay of the rule was not justified. Important, they said that the act empowers the Secretary of Labor to set workplace safety standards, not broad public health measures. So they felt this went way too far, and the application for stays were granted. So at least in the 100 employer issue, and this may or may not be over. It just depends upon whether other parties try to move in different legal directions, or possibly the Biden administration could attempt to narrowly tailor a new vaccination plan that was more specific to the concerns of the court as opposed to the broad direction initially. That is yet to be determined. So I want to move on to a discussion of future pandemic response. This is important, I think, for a couple of issues. I mean, obviously, if Congress takes action in this area, it will affect commercial insurance companies. Recent legislation has kind of roped in workers' compensation insurers as well. And so it's something that, everyone should be aware of, especially the conversation and understanding the issues, regardless of where you come down on it, if you have a perspective in this area. So there's no question there's been unprecedented business losses, and during the pandemic, losses all around the country on every aspect, of course, human toll, paramount. But there continues to be massive amounts of litigation in federal courts concerning business interruption coverage. By and large, industry has won these suits in the early stages due to the fact that business income coverage is provided in part for, property coverage, direct physical and tangible destruction or loss to property and really for only a period of restoration is its intent. Most, if not all, of the current losses have been untethered to property damage, and basically just a loss of use of the property, mainly due to government shutdown orders, which has nothing to do with damage or destruction to property that needs repaired, which is what the coverage was initially sold for in the beginning. Consequently, policymakers, especially Congress, have been looking for future solutions. And some believe that, existing programs like Parallels TRIA, which is Terrorism Risk Insurance Act, can serve as a backstop for this type of loss. Congress has continued to hold hearings on the subject, as well as introduce legislation such as by Carolyn Maloney from New York, House of Representatives. A recent proposal was introduced late last year, which has many additional disconcerting issues, and kind of a second version of a proposal called PRIA, or Pandemic Risk Insurance Act. As a brief background, the discussion continues to center around what mechanism would be best going forward for the next pandemic, especially in regards to employers. I mean, obviously we want small employers, all employers to be viable and protected. But the costs of these situations are enormous. Some believe that, some may say a fully private solution can be worked out, but there's very few people discussing that, just the industry. That the industry could handle it on its own. I don't think that's viable, and anyone has really put forth a strong argument concerning that. There are folks who feel that a public-private partnership, such as with TRIA, with the industry having a piece of this concern up front, but with a federal backstop, may be workable. And then some believe, and a lot of industry, I think, has evinced the fact that this is so large and so enormous of a risk, almost immeasurable, that this is really a government only solution concerning these issues. So as we continue to look at this new legislation that was filed, HR 5823, again, we're not sure this bill actually goes anywhere, but it has clearly created discussion among members of Congress, and I think everyone is trying to fashion what type of relief could happen in the future. So as more background in understanding the issue, we obviously have employers who want to continue to operate and fulfill obligations, especially where possible through a pandemic. However, issues like this PREA case are disconcerting because of the inability to put our arms around what this risk is, and to have industry be able to absorb even a fraction of it, even if it's 5%, but if it's an unlimited liability, 5% of an unlimited liability is still a really large number. So that continues to be looked at. There are foundational concerns, as we've mentioned. There's not a lot of data for these pandemics in the area of property and casualty losses for underwriting and modeling exposure. There's many concepts discussed, but unlike other insurance loss, the recent pandemic showed that there's too many variables in state and government health and executive orders concerning exposure and ability to enter properties, and various public protection measures that again make a very unstable environment for trying to quantify risk. And then there's been many discussions about the existential nature of forcing the industry to cover these issues. The AIC, the National Association of Insurance Commissioners, the body that regulates insurance in the states nationally, said these are difficult risks to insure. Insurers are not well suited for global pandemics where there's this concentration of risk for extended periods of time, losses across the board, sort of this adverse selection, if you will. And then estimates came out that the pandemic itself business interruption loss, just pure loss of use of the property, could exceed industry aggregate reserves in a couple of months. So really significant risk here. The current PREA proposal also preempts state-based insurance. It doesn't allow for risk control measures, exemptions, exclusions. It's basically opened the concept wide up, where business interruption now is, as I mentioned, tethered to real physical damage to the property for a period of restoration. There's this concept of, parametric non-damage business interruption, which basically means that there doesn't have to be any damage to the property, but there's there's a mandatory, and so there is a mandatory offer by insurance companies. And again, I mentioned in the definition that is including workers' compensation and all commercial insurers, as well as the offering of this issue. So again, we don't know what kind of take-up rate would be for this proposal. We don't know if it will move. Stranger things have happened, although it hasn't at this point. There's other pressing concerns for Congress, but there is many constitutional issues here. And then again, this current proposal took all caps off. So even where the previous version had some caps, and TRIA, for instance, has caps on exposure, the caps in these particular areas were taken off. So again, something to definitely look at. It's also important to point out that even those that support, a public-private partnership, in their mechanisms would require some risk management, and other prescriptive treatment of these issues more clearly defined, as opposed to just this open-ended liability. So lots of concern there. Not sure where this bill is going, as mentioned, but when it was introduced, there was large PR campaign and a lot of support by industries affected by COVID, including there's a business continuity coalition, travel, motion picture industry, restaurant, real estate, hotel, and other various trades. So I'm sure they're all providing some leverage to Congress to take a look at this much more seriously and move forward on that. Briefly, just wanted to bring up the federal cannabis without going into it in too much detail. You have the slides. We have a continuing effort to move the Secure Enforcement to SAFE Act and the Clarifying Laws Act around insurance to try to provide in some part a safe harbor for insurers and others who, for instance, in states that are required to reimburse from being, conversely attacked by the government. There has been work done in these areas, as we have discussed, and others I'm sure you're aware. The Claims Act is more insurance only. The SAFE Act includes financial institutions and insurers. It limits the ability of federal agencies to interfere with dealing with cannabis businesses, solely dealing with them, with nothing else. And for instance, like money laundering laws, it prevents it being considered unlawful activity or proceeds from a criminal enterprise, simply just for basically dealing with those. In regards to insurance and coverage of these areas, there's no mandatory duty to deal with these entities if you do not want to, but that the insurer, would not be held liable pursuant to any federal law solely for engaging in these activities. Just interestingly, I mentioned that the latest attempt was to attach this bill. The SAFE Act has passed the House a couple of times, no activity in the Senate. The latest attempt was to include just the last couple of months in the NDAA, which was the National Defense Authorization Act, which, authorizes our defense spending. And it was kind of a tricky mechanism, but again, it came up short. The Senate would not include it. Again, I think the issues here become many Republicans continue to be, and moderates continue to be concerned with expanding cannabis legalization, while more on the Democratic side feel it doesn't go far enough. The progressives don't feel that that it moves the needle much, and would also want some significant criminal law reforms as well attached to the bill. So it seems to be at a stalemate. On a concluding note, the Representative Perlmutter from Colorado, who's been the champion of these bills and the proponent, announced he would not be seeking re-election this year, and so therefore, a huge gap in advocacy for these will be missing in Congress. So outlook doesn't look that strong. Just wanted to briefly update FIO, updated TRIA call. They, generally, Department of Treasury has sent out an updated TRIA call that is annually sent to determine risk exposure in the marketplace for terrorism risk insurance, I mentioned earlier, and the federal backstop. The program recently expired in 2020 and was renewed until 2027. The current ask is for updated granular information on captive insurance and cyber insurance. Seeks to understand the use of cyber extortion coverage, which may or may not extend coverage for ransomware payments and loss information concerning ransomware payments. There's a May deadline regards that one. And just one other issue I wanted to jump into really quickly, and it's kind of a state-federal issue, is this issue of take-home liability. We've seen some cases come across in the last year and a half. Has not been the picture of consistency regarding the matters, and I just provide some cases for context rather than specifics. So again, for any of the legal references in this presentation, I encourage you to do your own legal research. These are merely provided to add context for the discussion and understanding. All of these cases may be in various avenues of appeal or not, and outcomes can change on any given date. Some of these are just looking at decisions from this particular court. So, for instance, in Maryland, the Southwest Airlines case, spouse died due to contraction of COVID-19 that was allegedly brought home from their spouse from an airline training session. The lawsuit by the spouse was directly against Southwest for negligence and held that the employer owed no duty to the employee's spouse for contraction and potential spread of COVID-19 from the workplace. So there was no duty to the employer to take care of for that situation under a tort law. I mentioned Cusiemba, Northern District of California, which is interesting. Similar situation. We had a brought home, a spouse died. So these are terrible cases. These are, people have lost their life through this. They're filing suit, but they're seeking damage for negligence per se, premises liability, loss consortium, and the court found that, again, upheld the exclusive remedy provisions of the California Labor Code, and again, so did not allow a direct suit in those particular areas, which is something to look at because we have seen erosion of exclusive remedy in various states, and sometimes courts look because of the concern or because of the terribleness or the atrociousness or the harm done to try to find an erosion or to get around the exclusive remedy. And then we have the Steve Candy case in California State Court of Appeals. And again, this is where the employee and the spouse both died from contraction allegedly at the employer's place of business. Failure to implement adequate safety measures, so on and so on. Employer filed a motion to dismiss based on the claims being barred by the exclusive remedy of the California Labor Code. And more specifically, that the claims were barred under the derivative injury doctrine, which makes the exclusivity applicable. That is, causes that flow basically from the initial injury. And of course, in this case, they alleged in court that, in fact, the spouse contracted it from the employee bringing it home from work. So there was this apparently derivative injury, but court said no, the suit was not barred by the exclusive remedy because it was not a derivative injury. It was a new injury, a new injury of itself. So again, I don't think this. I don't know if this provides you any guidance. I think it's more just the understanding of where courts are going with this issue. But I know we continue to monitor this, and I think it's something that if it's not on your radar, it probably should be for various reasons, depending upon your perspective. So with that, I'll stop. I ran a little long. I want to thank everyone who's joined the call, and I hope some of this information was useful to you in your endeavors. And if there's any quick questions, I'll be happy to try to answer them.